And now I'm turning to Emerson Sykes, who is a staff attorney at the American Civil Liberties Union. He's working on the right to speech, privacy and technology program of the HCLU. And before that, he was working as a legal advisor for the International Center for Not-for-Profit Law. So Emerson, it's to you.
Thank you very much, Steffi. It's a pleasure to be with you today, and thank you to INCLO for the invitation. I'll just, as you mentioned, my background is in human rights law. So I've spent my career going back and forth between international and domestic human rights law. So it's good to be amongst my people in the INCLO community. So it's a great pleasure to be with you. I just wanted to talk briefly about the right to protest and the struggle for racial justice in the United States through the lens of the work of the American Civil Liberties Union, where I currently work. So as many of you probably know, the freedom of assembly and the freedom of speech are guaranteed under the First Amendment of the US Constitution. So doctrinally, we have some of the strongest protections for speech, I would say even in the world. But in the streets, as we've seen, it can be quite a different story. We also have the Fourth Amendment protection against the use of excessive force, but that has been violated time and time again, as we've seen over the last several weeks, as people have been protesting for Black lives and against racism. The American Civil Liberties Union, where I work as a staff attorney, has been defending civil rights and civil liberties for 100 years. Our cases have included many that involve protest rights and the fight for racial justice. We started out defending labor organizations and anti-war activists, many of whom were immigrants in 1920. And throughout the century, we've brought landmark cases to advance civil rights movement in the 1960s, as well as later efforts to protect women's rights, LGBTQ rights, disability rights, reproductive freedom, and all sorts of other issues. We've brought cases on behalf of people whose views we agree with, on behalf of causes that we support, but we've also made a name for ourselves, controversially, for bringing cases on behalf of people whose views we despise, when we think that there are important constitutional principles at play. So I want to just give one example, which I think is illustrative of this sort of unique feature of the ACLU and why we think that the fight for the right to protest can't only be for the people who we agree with about structural inequality, but also for those who are on the other side. So the example I want to highlight is a case called Brandenburg v. Ohio. And in that case, it was from the late 1960s. The ACLU represented a Ku Klux Klan member, an avowed racist. And in that case, the Supreme Court defined incitement narrowly so that it protects a broad range of inflammatory speech. Basically, this was a Ku Klux Klan member who made a video saying all sorts of horrible things. He was prosecuted for it, and we represented him all the way up to the Supreme Court. And in that case, the Supreme Court created a rule saying that just saying horrible things is protected by the First Amendment. In order for it to be considered actually incitement, you have to intend to incite unlawful activity. It has to be objectively likely that that activity is going to occur, and it has to be imminent. The harm has to be imminent. So just ruminating about all the horrible ideas that you have is protected by our First Amendment, unless and until there's actual incitement to imminent unlawful activity. So why would the ACLU take that case though? Why would we represent a Ku Klux Klan member? Well, we did it not on some theory that human rights are universal, though we believe that. It's actually in practice that every day we use that precedent from Brandenburg v. Ohio to defend all sorts of protesters and speakers who are accused of incitement. That same constitutional test is now being used to insist that incitement charges against protesters for Black lives must meet that same high standard recognized in Brandenburg. We've seen a handful of cases, and it's likely to be more cases soon, of federal charges under accusing folks of incitement to riot over the last few weeks. These are mostly young African-American people who are being accused of incitement. And just as Clarence Brandenburg, the Ku Klux Klan member, had the right to inflammatory speech, so do these young folks as well. So we're working on a whole variety of issues related to the right to protest and structural racism. But currently, I want to talk about a couple of cases that we are bringing in relation to the current protests. But before we get to that, I want to highlight one case that I think is also illustrative of the kind of things that we've been trying to do. This is the case of DeRay McKesson. He's an activist that's affiliated with the Black Lives Matter movement. And in his case, we've asked the Supreme Court to review a lower court ruling that held that Mr. McKesson can be held liable for injuries to a police officer during a protest in 2016 after the killing of Alton Sterling, a Black man who was killed by police in Louisiana. And the lower court said that even though DeRay McKesson didn't know who threw, we don't even know what was thrown at the police officer, to be honest with you. We don't know the police officer's name. We don't know who threw something, and we don't even know what they threw. But still, the officers sued DeRay McKesson as an organizer of the protest, and the lower court said that he could be held liable potentially because he allegedly led protesters into the street. And when he led them into the street, it was inevitable, it was foreseeable that there would be a clash between the police and the protesters, and therefore he could be held liable for the foreseeable results of his illegal action. Now, we have, as I said, asked the Supreme Court to review and reverse this decision because we strongly believe that it's a very dangerous precedent. If protest organizers can be held liable for anything that happens during a protest, even if they had nothing to do with it, I just have to underline this again. Even the officer who is suing DeRay McKesson does not allege that he knew who did it or had anything to do with it or approved of it. He just said that because you were a part of this protest, you had them engage in some level of civil disobedience. You're then on the hook for everything that happens. And of course, the chilling effect will be dramatic if this precedent is allowed to stand. Who would organize a protest if you could be held liable for anything that anybody does during that protest? So I think this is a really important case. We expect to hear back from the Supreme Court in the fall, but I encourage all of you who care about structural inequality and who care about the right to protest to keep an eye out for the case of DeRay McKesson. Just now, that case is as I said, it's relevant to what we're seeing in the streets now because it was a Black Lives Matter protest. It was in response to a police killing of an unarmed Black man. In that case, it was Alton Sterling. But now we've seen over the last several weeks, people taking to the streets because of the killing of George Floyd, Breonna Taylor, and the vigilantes, the former police officers who killed Ahmaud Arbery in Georgia. So the ACLU is also very active in rapid response to these situations. We have affiliates. Those of you who are in the INCLO family will know that the ACLU has affiliate offices in all 50 states. And this is invaluable as we try to respond to this nationwide crisis. And our affiliates in several states have already brought lawsuits, mostly focusing around the use of excessive force against protesters. And I know Dr. Haar is going to speak in more detail about the use of tear gas and rubber bullets and other so-called less lethal weapons. But this is an issue that we're actively litigating all over the United States. In Minneapolis, the same city where George Floyd was killed, we filed a lawsuit on behalf of a journalist who was hit by rubber bullets. Again, our claims were based on the First Amendment, freedom of speech and freedom of the press, as well as the Fourth Amendment right to be free of excessive force from the police. Excuse me. In Seattle, Washington, we filed a case on behalf of Black Lives Matter of Seattle, again, saying that the police have used excessive force with the use of tear gas and with the use of rubber bullets against totally peaceful protesters. And I'm happy to say that a judge in that case actually issued a preliminary injunction saying that while the case is going on, the police are prohibited from using those so-called less lethal weapons against protesters. And I have to say, it's tragic and it's sad that we need a judge to tell the police not to shoot rubber bullets at protesters. but that's unfortunately where we are. Another case that I would just highlight is you may have seen coverage of in Washington, D.C., I guess it was a week and a half ago now, there were protesters, peaceful protesters outside of the White House who were cleared using tear gas in order for our president to have a photo opportunity. And we've actually sued, saying that they were using excessive force against the peaceful protesters, again, under the Fourth Amendment and the First Amendment. And we hope to prevail in that case as well. And we also have cases in Indiana and North Carolina bringing similar claims. And we've already gotten a similar injunction in North Carolina saying that police cannot use tear gas and rubber bullets against protesters. So we're fighting all over the country to try to protect protesters' rights. And I also have to mention just briefly, because I'm in New York City where we had a curfew put in place during the height of the protests, that we also at the ACLU threatened to challenge those curfews as unreasonable restrictions on people's civil liberties. And both the mayors of New York City and Los Angeles backed down under the threat of those lawsuits. So we never actually had to bring those suits, but we count them as victories nonetheless. So needless to say, we're keeping very busy. The current perfect storm of police violence, COVID-19, and our cruel and incompetent president can make things seem very bleak. But our country and even the ACLU itself has been through a lot of dark times before. And I can assure you we won't give up in our pursuit of freedom and justice for all. And as you may have seen, our Supreme Court just last week handed down two really great decisions. One on LGBT rights, protecting LGBT employees from discrimination and termination. And also another one protecting undocumented immigrants who arrived as children. So we know that courts are imperfect tools for justice, but we had a little bit of good news last week and we live in hope. So I'll stop there, but I'm happy to answer any questions and I thank you very much for your attention.
Thank you so much, Emerson. I take this opportunity to remind our participants that we welcome your questions in the chat function that you can see, I believe, somewhere here. I really liked, Emerson, how you went back in history and highlighted that one of the probably the most controversial cases of the ACLU actually served you in protecting today's protesters. And I think it's, as a civil liberties attorney and a civil liberties lawyer, it's really inspirational to see how many court cases you bring and you actually win. Even sometimes you don't have to bring the case and you win nonetheless. So it's really inspirational. Thank you so much. The headlines are full with what's happening in the US, but there are protests that are ongoing in other countries as well. And now I'm turning to Putri Kanesia, who is the Deputy Director for Advocacy at Contras, which is the Commission for the Disappeared and the Victims of Violence. And she will speak about their experience in Indonesia with protest and structural discrimination.
Okay, thank you, Steffi. Hello, everyone. Good evening from Jakarta. It's very honor for me to be a part of this webinar and have an opportunity also to share about the freedom of expression in Indonesia. So I will start my presentations by, Okay, so I will start my presentation by sharing about the Indonesian situation before 1998. So I must to highlight this period before 1998 because during the authoritarian regime of Suharto, our president of Indonesia at the time, he gave full power for the Indonesian military to control everything about the civil society. So Suharto, who also has a background of military, also put the military general in many government positions, like from the minister until the legislator. So it's impossible for the civil society actually to be criticize the government regulation or policy, or you will be end in jail. So the government also control the media, a lot of censorship at that time. So the journalists on that day is only can cover news regarding about the government achievement or any others positive from news from the government. So at the time, it was very difficult for civil society to know about is there any human rights violation happen in Indonesia at the time. But the political situation then changing after the resignation of Suharto in May 1998. After 32 years of in power and as an Indonesian president, and he handling his position then to his vice president, which is Baharudin Yusuf Habibie. The period of transition called reform era, where the democracy at that time is being discussed by civil society. So after the reform era in Indonesia after 1998, Indonesia then have like several regulations that respecting the freedom of expression. Like we have like the freedom of expression in public. A year after, we also have like Press Freedom Act, which is that year Indonesia become the first country in Southeast Asia who has like a Press Freedom Act. And we also have like human rights law, and in 1998, the government also ratified the Convention Against Torture. So why, what happened after 2 decades? So I wanna move on now about the Indonesian situation after 2 decades. So why I have to make a comparison between 1998 and after 2 decades. So because many people believe that in our situation in Indonesia right now, it tend to be like a return to the situation in Indonesia before 1998. So in this period, the shrinking civic space become the real challenges for us. So we documented that there are a number of violations against the civil liberties in Indonesia. They are getting increased, the police brutality during the mass demonstrations, people being criminalized just because they are trying to criticize the government through the social media. The parliament also released many regulations that control the civil society until the private sector. So this picture telling about the large-scale mass demonstration outside the parliament building in Jakarta in September 2019, last year. So contrast also be a part of this rally. We call it the Reformasi di Korupsi rally or Reform Corrupted rally, which is the biggest number of mass demonstration after the 1998 demonstration. So the protester at the time aimed to oppose several controversial regulations that scheduled to be passed by the parliament at the time, such as the revision of the penal code by the parliaments that will criminalize that, like one of the article in the revision of the the penal code will criminalize the extramarital sex and will also defamation against the presidents. So the rally at the time became class after the police officer then fired the tear gas and deploy several water cannon to disperse the crowd. So from contrast documentations, there are more than 1,000 students at the time being arrested and by the police officer. So I will move on to second cases when about the racism in Papua. Previous speakers saying talk about the Black Lives Matters. Actually, in Indonesia, we also have the similar case of racism in Indonesia that happened to the Papuan people. So Papua located is in the eastern part of Indonesia, and the people is often being criminalized and also being discriminated by the government. So there's one cases occurred in August last year in Surabaya, East Java. So at the time, the security forces they are allegedly yelled monkey to the student, the Papuan student at the time, because they are accused disrespecting the Indonesian independence on the August by reportedly damaging Indonesian flag in front of their dorm. So no one knows actually at the time who saw who damaged the flag, but the security officer at that time accused that the Papuan student who make a damage of the Indonesian flag. So after the racial case to the Papuan student in Surabaya in East Java, several riots broke out in Papua and West Papua. They are like protested against the racial case in East Java. And several demonstrations also occurred in several areas in Indonesia, not only in Papua and West Java. That's a big riot at the time in Papua. So however, the government at the time responded the riot by blocking the internet in Papua and West Papua for almost like 2 weeks in total to reduce the escalation. So at the beginning, they are like have the internet throttling, but at the end, they really ban the internet for like more than 2 weeks in total. So the journalists at the time, journalists inside the Papua, they cannot like inform the real condition about what happened in Papua after the riot to the people outside Papua. In the same time, the people who are outside Papua also cannot asking about knowing about the real condition in Papua after the riot. So there's no accountability actually, unfortunately, by the government about this policy. Actually, from several riot in Indonesia, several mass demonstration, I mean, from the previous cases that I mentioned, and also the Papuan rally, riot in West Papua and also in Papua, the government also made the policy to like block the internet. So this is the third time of government of Indonesia to block the internet without any accountability by the government. So I will stop here so we can discuss. Thank you, Steffi. And thank you, everyone.
Thank you, Putri. That was really interesting to learn about all these cases that we are able to read very little about in the headlines. You might hear a baby crying in the background. That's my baby, and my partner is taking care of him. So don't worry, he is fine. With that, I turn to our last speaker of the day, Rohini Haar, who is from Physicians for Human Rights. We have worked with Rohini since 2014, creating a report on less lethal weapons or crowd control weapons. And Rohini is an ER doctor at Oakland, California, and also a medical expert for Physicians for Human Rights.
Thank you. Perfect. Okay. Hi, everyone. Thank you for inviting me today. INCLO has been at the forefront of much of the research on protests and crowd control weapons, so I'm excited to share some of that information with you. If you'd like more details, please see the Lethal in Disguise report from 2016 on the INCLO site, as well as on the HCLU and Physicians for Human Rights sites as well. Most of what I'm sharing today is in that report. And I will just set the stage for a few moments about the decision to use force and how that's manifested in protests. And then, because I'm a doctor, I will show some pictures. So I want to make 3 points today. Point one, I think our other speakers have made much more eloquently than I have, but is that protesting is important. When people are trying to make their voice heard, there's only a few ways that we can communicate with our leaders. We can vote, we can lobby, especially if we have money, and we can protest and demonstrate. This last one is really the only one to use in times of urgency, when something can't wait until the next election or for political pressure to slowly move the needle. And protesting is one of the few ways that the ordinary citizen can make their voices heard above the din. And when that right to protest is repressed by weapons, in similar ways that other rights for minorities are repressed by brutality and structural violence, we know we have a problem. Point two is that the use of force must be better regulated. But we don't have to start from scratch. There's been extensive work on how to guide the use of force for decades. The UN actually has principles. Most police departments, almost all 18,000 of them in the United States, they have their own guidelines. And there's really 3 fundamental principles that we need to think about. When you're thinking about the use of force, it has to be necessary. So the principle of necessity is that the use of force in a protest is an absolute last resort. When dialogue and communication have failed, or when there is a clear and imminent threat to public health, not to property, but to people. The second is proportionality. That means that even when some use of force is needed to protect people, that force is used proportionally. Someone throwing an apple at the police does not necessitate dispersing the entire protest or firing weapons. The third is legality, and I'll put in parentheses misuse there. So even if the use is proportional and necessary, it still has to be properly used. Bullets can't be fired at people's heads or from close range. Tear gas can't be used indoors, or the canisters can't be fired directly at people. And all these weapons need to leave avenues for people to exit safely. And most fundamentally, the use of weapons is supposed to protect public safety and de-escalate tensions, not to disperse assemblies, whether or not they're deemed legal or illegal, or to intimidate people from protesting. Point 3, when these guidelines are not met, injuries and deaths can happen, particularly when they are misused and when there's no respect for law or for life. I'll show a few pictures. Some of them are a bit graphic. This is not to disgust you, but because I believe it is so important to see what injuries there really are and grapple with the reality very concretely. Just give me a second. So just again, warning, some of these might be disturbing, but these are kind of the injuries that you can see from things like shotgun pellets. So when there's scattershot of weapons, even rubber bullets, as you can see on this one, they can hit people all over. You might be aiming for center mass in the chest, but you're going to hit someone's head and ear. This is a plastic bullet of a young man who hit just above his eyebrow. But if that had gone down another inch or so, he probably would have lost his eye. As in this case, where you can see that that bullet penetrated the eye and caused permanent blindness. This is a gentleman who had multiple injuries from scattershot to the back. You can see the skin injuries, but what you can maybe not notice is that he has a lot of bruising because of internal bleeding. Rubber bullets can cause skull and brain injuries, again, when they're shot from very close range or when they hit the head. Tear gas, what we usually think about is skin irritation and severe pain, which most of the time is transient, but can last a lot longer. It can also cause chemical burns. It can cause allergic reactions. And this is in a soldier, it can cause chemical burns and sort of blistering as well. And the one we don't think about is, even though it is called tear gas and it affects the eyes and the skin, you have to breathe all your life. And when this toxic chemical gets into your lungs, it can cause pretty severe chemical lung injury as well. You can see all that white stuff in the middle there is not normal. On the right, you can see a normal lung, and on the left, you can see the kind of skin and tissue breakdown that you can have with excessive tear gas exposure. Even the canister itself can cause a lot of injuries. In fact, in our studies, most of the deaths that you see from tear gas are from the canisters, especially when they hit the head or the face or the eyes. And there's a whole host of other weapons. Tear gas and rubber bullets are not the only ones that police and law enforcement use all over the world. This is just an example of water cannons, which people think are safe, but they cause a lot of secondary injuries as well. So you can see that when these principles of necessity, proportionality, and legality are not fully met, that these injuries are going to be exacerbated and you're going to see a lot more. And that's exactly what we're seeing in the United States right now. We have a researcher trying to identify all the people who've had severe injuries just in the past month, and I think we have over 50. And that's just a gross misunderestimation of what probably the reality is. But you can also see how much a protest movement can change things. In the last 4 weeks, dozens of US cities have banned rubber bullets or put a moratorium on tear gas during COVID. None of this would have even been a dream 2 months ago. But I hope that the legislation does not end there. It's not enough to ban some bullets and not address the real structural racism that got us here in the first place. It's low-hanging fruit, and it's a fine first step, but not the end. So I'd be happy to answer any questions in the discussion period. Thank you.
Thank you, Rohini, so much. And I believe that it's really important to see those pictures because they really show you how these mildly sounding crowd control weapons can cause real harm to people. And thank you also for ending your presentation on a more hopeful note. And now I'm turning to the panelists, some individually and some addressing all of you with some questions. So my first question is to Putri. You talked about the lack of accountability, which I know from my experience, and I know that is an experience for many INCLO countries and many countries around the world, that there is a lack of accountability for actions that you mentioned, like the internet shutdowns, which is clearly against international law. Were you able to take these cases to the courts, and how do you see the court's role in holding the government accountable in Indonesia?
So yeah, I forgot to mention that after the government make a internet shutdown in Papua and also during the rally in Jakarta in September last year. So Kontras and several civil society organizations in Indonesia, sorry, we sent an appeal to the administrative court, and we are all like sent an appeal to the president and also the Ministry of Law and Technology, because they are this minister is they are make a like internet shutdown at the time in Papua and also in Jakarta. So in this month on the June 3rd, finally the court decided that the president and also the Ministry of Technology and Information and Technology violates the law. So I mean, even though I mean the court only declares that the government violates the law, but as a political, it's really bad for the government that the court can say that the president is violating the law. So several political people's like now force the president and also the ministry to like say the public apology to the Papuan people and also the people who can become like the victim because of the internet shutdown. But until now, there's no action from the government. But for the international advocacy and also for the Indonesian advocacy, I think this is also can be like the good things to share. I mean, like the civil society can do appeal to the government. Yeah.
Thank you so much. We have a question for Rohini and Emerson. Can you speak to the difference between where advocacy on these issues should be focused at local and state level vis-a-vis federal law in the US? Thanks. Emerson or Rohini, can one of you address this?
Sure, I've unmuted myself, but I think the host has to turn on my video. Okay, there we go. Yeah, it's a good question. I mean, in a federal system like the United States, so much of what impacts us is local. And I think in particular with regard, you know, the right to protest is protected in the US Constitution. And excessive force, as I said, is prohibited under the Fourth Amendment. So a lot of our cases are brought in federal court, but one of the cases, the case in North Carolina, was brought in state court, entirely using state constitutional claims. And that's sort of a strategic decision based on which state you're in, what the constitution in your state says. Some state constitutions are actually more protective than the federal constitution. So in some cases, it makes sense to bring the case under state courts. But I think one really important factor in the United States is that we have a federal system, and policing is even more localized. So we have hundreds, if not thousands, of local police departments and different law enforcement agencies, and they all have their own policies and procedures. Of course, they're bound by the Constitution, they're bound by state law, but they have their own use of force procedures, they have their own disciplinary procedures. So one of the things that makes police reform in the United States so challenging is that it's so decentralized. So even when we're going to federal court, we're often suing local police departments. Like in Seattle, we were in federal court, but we were suing the Seattle police. So it's a complicated, set of circumstances that you have to navigate to decide what kind of case and in what forum. But one of the big factors is the fact that we don't have a national police force. We have lots and lots of local police forces. So tackling this type of behavior requires a state-by-state approach. But of course, at the ACLU, we're a national organization, so we also prioritize cases that will have the broadest impact beyond any particular locality. I hope that answers some of the question.
I'm muted. Rohini, do you have anything to add to that, or it was a?
I guess the only thing, I think you addressed all of the points. The only thing I've been thinking about more is that I've mostly focused on the use of crowd control weapons, and none of it is regulated. The manufacturing, the sale, or the use. And I think the use part, and maybe the use can be local, but maybe one other avenue for federal or national or even international level regulation is on the manufacture and sale. For instance, a couple years ago, I worked with INCLO and was listening about a case of South Korean tear gas being sold to repressive regime in Bahrain, and then being abused there. And there was a lot of advocacy around that. So that made it stop, essentially. But that's happening all over the world. And so that level of kind of international guidance can also help. And then I would also say, we also don't have to start from scratch there. There's, the Chemical Weapons Convention bans the use of riot control agents in warfare, but has a loophole for the use in civilian policing. But those kind of conventions could maybe be used also in the international level to put pressure on national policing as well.
Thank you. And I see that the person who asked the question is really happy with your answers. So thank you so much. And I want to turn to Nersen and ask you that you said that remedying structural discrimination is a slow process and it's very imperfect. What do you think? Is there anything to learn from that process in South Africa? What we could do differently? What we should be mindful of when something similar is unfolding in our respective countries?
It's almost 50 years of structural discrimination, carefully planned and implemented. And we've been a democracy now for about 25 years, but it requires, the one lesson I would say, it requires a lot of will for the state to drive the change in people. Remember, it's a generation that's been immersed in this. So despite the fact that we don't have this discriminatory laws at the moment, it's there. It's unconsciously there. If you look at, I'll just give you a few examples of just where people live. The high level of poverty in informal settlements, that has not changed. In fact, in many instances, the situation is far worse now than it was in the pre-1994. And that's when I spoke about the corruption for the 10 years. So this year we would be voting again in 2024. 2024 is the next general election. That's 30 years of democracy, but we lost 10 years. So the biggest lesson for anybody that comes out of something like this is that you need to have processes in place. You need to have a support structure in place, and civil society organizations, together with private and public sector groups, need to work together. That's what I would say. Thanks.
Thank you, Nelson. And I have a question also for Amr. And I know from our working together that you work under extreme circumstances, and your work carries an extreme danger for you. And nonetheless, I always see you and your colleagues as continuing, pushing through, bringing cases to the court. And I'm curious what keeps you going. Is it that the court rulings are reliable, or is it something else that would be really inspirational for others to hear?
Yeah, thanks for this question, Stefania. Basically, what keeps us going is the communities that we are working with. It is not us. It is the persistence of the communities that we are working with. As long as there are cases brought up to our attention, we have no other option than engaging with them. And this is the legacy of 2011. I mean, maybe we are of course living under very restrictive circumstances, more than what you think, by the way. Egypt is not a country that is always on the radar. It's not Turkey, it's not Brazil, it's not India, but it is definitely much worse than Turkey, Brazil, and India. But again, the legacy of this revolt of 2011 is still alive. And it's still alive in the communities, that there are people who are mobilized not to accept it anymore. And since those people are mobilized, we have no other option than working with. As for the courts, one of the major paradoxes of the regime in Egypt, that they need the court, and that they need the court, and they need some minimum independence of the court, basically for the international market, in order to be able to attract business, in order to be able to attract foreign direct investment, in order to be able to sign loans with the IMF, for example. You have to keep a certain degree of procedural coherence of the judicial system intact. So you can basically manipulate the parliamentary election. You can close down all the media outlets, the independent media outlets, of course, but you can't basically close down the judiciary altogether. Otherwise, you will not be able to have a space in order to settle the disagreements between the business and the government, or between the business and each other. And from this leeway, we managed to find a foothold for ourselves, especially before the high courts, the Supreme Constitutional Court and the administrative judiciary. And then we start again, as I just pointed out in my presentation, we start to make buzz as much as we can on the social media platform. Of course, there are a lot of informal ways of interference in the work of the judiciary. I mean, there's no room in order to name this, but at least the situation is still less severe than in the parliamentary, in the election, or in the media, or in any others. I'm not sure if this answers your question.
Definitely does. I still admire your work. Then a question for all panelists. In one of our research reports, Defending Dissent, we recommend that the institutional design of policing institutions needs to be radically reconsidered. What do you think, what is in your opinion, some of the changes that are the most pressing that we need to see in reforming police institutions and rooting out structural discrimination? So when we want to address structural discrimination, what sort of changes we need to see in policing and police institutions? Any of you would want to address that question?
Hi, Steffi. It's Emerson. I would love to hear from others, but I can start if that's okay.
Yeah.
I mean, as you've probably all seen, we've seen a dramatic shift in the public debate in the United States, especially around what it means to have meaningful police reform. You've probably seen on social media and elsewhere that the current ask is for defunding the police. And that can be from the calls ranging from, limiting the amount of, our police budgets are astronomical. Millions, sometimes billions of dollars are spent on policing, while public officials claim that we don't have money for all sorts of other social services, education, all sorts of other things that people desperately need, not to mention, of course, healthcare, which we don't have in our country as many of you do. So I think defunding the police has become the most prominent demand, and I think that's very easy in some ways, encouraging local police departments not to buy that new military tank. We've seen successes all over the country in that regard. In some ways, it's not that hard not to spend like hundreds of millions of dollars on a local police department. But I think going beyond sort of trimming the fat, I think we do have to get to the question of what is the role of police in our society? And how are we using the police and more broadly the criminal legal system, and especially incarceration, to do the work of all sorts of other social services and address all sorts of other social problems that really have nothing to do with the criminal legal system and certainly are not fixed by incarceration or criminal legal penalties. I mean, the list is very long, but for example, the ACLU has been doing work around decriminalizing sex work. Because whatever you think of sex work, if you think about the causes and the impacts, the idea of incarceration figures nowhere into a reasonable solution to that type of social issue. So I think defunding the police, reconceptualizing the police, and then one more thing I would mention, which is more of a legal technicality, but it's gaining a little bit more broad-based understanding and acknowledgement of its importance, is something we have in the United States called qualified immunity. And so one of the things that we're really trying to push for is the end of qualified immunity. And this is a court-made doctrine where basically it provides extreme protections from accountability for police officers. So basically, in order to hold a police officer accountable for violating constitutional rights in the United States in federal courts, you have to overcome qualified immunity. So you have to prove not only that the conduct was unconstitutional, that's just step one. You have to also show, sorry, there's a construction site outside of my window. But after you've shown that the conduct was unconstitutional, you then have to show that the conduct was unconstitutional under clearly established law. Now, the way that that's been interpreted is that the exact same situation has to have happened before, and the officer has known or should have known that that exact situation was unconstitutional. But what that means is that if anything about the situation in question is novel, if it's at night instead of in the daytime, if there were 3 people at home instead of 2 people at home, any sort of small detail that's different from previous cases can be used to say, oh, yes, this conduct was unconstitutional, but the situation was new and the officer couldn't possibly have known that under these special circumstances, this conduct was prohibited. But this applies in cases where people are like, shot in the face while lying in bed, but because there was a double door on the outside of their bedroom, it was not clearly established law that it was unconstitutional to shoot through the doors, for example. So ending qualified immunity can go a long way towards opening the door to more accountability for police officers, but that's only one thing. Defunding the police is easy in some respects, is harder in others, but that's also only one thing. We really need to reconceptualize the role that police play and what we're asking our criminal legal system to do.
Thank you so much. Nelson, I know you have something to say to this question.
Yes, Steffi. I think the question that you ask is a very important one. And in the South African context, I think everybody must remember that growing up in South Africa with apartheid laws, the police was the enemy, complete enemy, and so was the military. So there is this embedded fear of both groups, even to this day. Now, in the COVID-19 pandemic, both the police and the military had an absolute amazing opportunity to fix that perception, and they didn't. In the first week, they almost waged a war against civilians, complete war against the civilians, and you saw it in some of the pictures. So if you want to fix something like that, you'd have to have a complete transformation from the top. That is the thinking of who you employ into these positions. You know, they would have to be retrained. Current lots will have to be retrained that they are there to serve the public, not hurt the public. That's the difference. Thank you.
Thank you. Rohini?
I actually agree exactly with what Nursen said. And I think what I've been thinking about a lot recently is that there's a narrative of the police or the actions that are happening that are bad, either in the United States or abroad, or because of police who are bad apples. But if I could leave with one point today, it's that that narrative is a false narrative. And I mean, I come from the epidemiology department, and when you see that people in all of these different countries that we're talking in today, or all of the different cities in the US where this is happening now, like just purely just from a science standpoint, that's not a few bad apples. That's a pervasive, top-down, international problem. And so maybe that narrative is one place where anyone can start thinking about and changing.
Thank you so much. Actually, we run out of time. So I'm asking if any of the panelists have anything else to add, some final words. You can speak now. I don't want to stop you from doing that. But if not, then I thank all the participants for being here and managing with the time differences. I thank you all the attendees for paying attention. And I want to leave you with my favorite quote, probably ever, that I've read in Robben Island in Cape Town in South Africa. And it's as simple as that: freedom is a process. And I think it contains many of the discussions and many of the ideas that we discussed today. One is that it's never finished. We can never say that we are done. Freedom is a process also means for me that it requires strategic work. And it also means to me that if it's a process, then it's a process that includes many actors. Civil society, it includes policymakers, it includes social movements. So freedom is a process. And I want to highlight again INCLO's new website that I think was created under this understanding for social movement leaders, for activists, for journalists, for policymakers, and really shows the work that goes into achieving greater freedom around the world. So this website can be found on the link that is in the chat. Michael just put it there, and it addresses criminalization of protests in INCLO countries and also surveillance during the COVID-19 era, but it will be updated with a general, a more broad mapping out of criminalization of protests. So thank you everyone for attending INCLO's third webinar. Have a good day.